the state's table right now. And some of the defense attorneys, if y'all would not mind introducing yourselves and tell me who you are representing. And at least for the first part of all of this, I'm going to ask that y'all use your name tags to help me. I think y'all had at one point like placards that you could sit in front of you. We'll find them if they're, I mean, it's fine for now, but, and I know you, Mr. Short, but.
Good morning, Judge.
Good morning. Yeah, I mean, we don't have to do it right now. I'm just saying, as we move, you know, for the first couple of weeks at least, if y'all don't mind doing that for me. So, introductions.
Judge, Max Sharp, I represent Shannon Stillwell. My co-counsel is Mr. David Botts, who is also here, and this is next to me. This is Shaquille Kokomo. He has been working on the audio visual on behalf of some of the clients, including Mr. Stillwell. So he's been a big part of this case as well.
All right.
Shaquille Kokomo.
Are you an attorney or paralegal?
He's going to be a law school student.
Okay. Well,
he's a college graduate right now.
Fabulous. Good luck to you. All right. Thank you.
Good morning, Judge.
Good morning.
Carrington Matthews Sr. here. I represent Marquavius Healy in this case. I also have representing Mr. Marquavius Healy is my son, Carrington Matthews Jr., who is not here today, and also Attorney Teresa Mahfoud. They're all from my office, and we represent Marquavius.
Okay. And I had both of your names. I don't know if I have Miss Mahfoud's. Has she entered an appearance?
Yes, entered an appearance.
Okay. All right. Well, we can update that. Okay. Thank you.
You're welcome, Robert. Thank you.
Hey, Mr. Butts.
David Butts, Shannon Stillwell.
Good morning, Your Honor. Doug Weinstein. I represent Mr. Diamante Kendrick,
Okay.
along with my co-counsel Jay Apt, who's ill today, and Katie Hegarty, who's on leave right now.
Okay. All right. Hopefully, Mr. Apt will be feeling better
Thank you.
soon. You can pass that along to him.
I'll do that.
All right.
Good morning, Your Honor.
Morning.
I am Brian Steele, and I have the honor of representing Mr. Jeffery Williams, along with the Honorable Keith Adams. Sitting next to Mr. Adams is a law student. He's a rising second year, John Marshall Law School. His name is Griffin Lail, Griffin Lail, if it's okay for him to sit with us. It would be appreciated. If not, he will obviously.
Is he sworn in under like the Third Year Practice Act or?
No.
All right. So I guess he can just act as a paralegal for now. Okay. Good to have you.
Good morning, Your Honor.
Good morning.
Leah Alosky here for Mr. Rebellis Ryan. I am the second chair to Ms. Angela Williams, who is ill today. I think she's expecting a Zoom link.
She should be on Zoom, and I guess I should get on the Zoom as well. Give me a second to do that. Okay.
She is the lead counsel. I am the second for
All right. Ms. Rosser or Ms. Pursfield, will I find a Zoom link on my calendar or? Okay. Give me a second to get on there. Well, we came and tested everything yesterday, but of course the computer is not wanting to cooperate. Can I just go through Zoom for it? Trying to find my.
Salute squad. Welcome to Fly High Productions with Mr. Follow Up. So if you haven't been following me, been some changes and some drastic changes, and changes been made fast. So I might have lost you in the loop or whatnot. And if you look around the courtroom, seems to be a little decorated with some new people, shall we say. That's right, y'all. We got a new judge in here today.
Just not by, I'm not seeing her on the screen.
Oh, Your Honor, I'm here.
Okay, are you just not on video with us?
Right, but I'm here.
Okay, all right, well, good to have you. Hope you feel better. If you might be sick as well, I think. Okay.
Good morning, Judge.
Good morning.
Cole Westmoreland, Warren Gardner, on behalf of Marcus Nichols. And we have one additional paralegal, not paralegal, intern, who's not here this morning. If necessary, we'll introduce you to him.
Okay, that sounds fine. All right, so a couple of things that we need to try to figure out from the outset. What is pending that I need to make a ruling on, and what our schedule is going to be like moving forward. I know there are already a couple of weeks that the jury has been sort of told you'll be excused for this week, so I will honor that. But I need for us to try to be efficient with the jury's time. So whatever we all need to get sorted out in the interim before we bring them back, as much as we can do, I'd like to do that so that we can minimize the times when they're here, but we have to send them to the jury room to figure out things that we could have figured out before. And I know sometimes that is going to be unavoidable, but to the extent we can avoid it, I'd like for us to talk to each other beforehand, give each other a heads up about what is going to be coming in or what we think might be an issue, and deal with it without the, wasting the jury's time, basically. So Mr. Steele, on behalf of Mr. Williams, sent me yesterday a list of what he believes to be pending motions that still need a ruling. And I think I have one that I know of from Mr. Huey, and I'm just going to kind of hear from each party as to what, as the state as well, as to what y'all believe is pending that we need to get heard. And since I've already got Mr. Williams' motions written down, I'm just going to make sure, Mr. Steele, that I've got all of the ones that you believe to be pending. So I saw in your email a July 8th and a July 9th motion to recuse both Judge Glanville and Judge Krause, which I'm obviously, we're not going to do anything substantive here today. I'm just going to make sure I know what y'all believe to be pending. A July 10th motion entitled for a fair trial that is essentially to find out about whether there have been any other ex partes. A July 1st motion that's kind of a proffer about something that happened with a jail call, evidence that's already been taken care of. And I mean, I'll look back into that. But a July 18th motion to disqualify two of the prosecutors. a July 10th motion asking, I guess, prospectively for a fresh look maybe at 24-8-801. And then you had also provided an amended witness list and a notice of filing. Are there any other pending motions for Mr. Williams that I didn't include?
It's not a motion that filed. May I address that just for your edification?
Sure.
Okay.
And are you going to file it? You're just giving me a preview, or?
I could file it.
Okay.
I'll do whatever the honorable court desires. So I just want to bring to the court's attention, to be, fair to the
Okay.
court. May I approach, Your Honor?
Yes. And it may be easiest to just hand it to Ms. Pursfield. And y'all, it's on my mind right now. Before we all leave here today, I want to make sure that my staff has cell numbers for everybody. Okay. All right.
So I've handed this honorable court's co-worker and the state 2 cases, PROPST versus Morgan, MORGAN, and it's 288 Georgia 862, 708 Southeast 2D 211. And if you look at page 2 of the copy of the case that I've handed to this honorable court and the state, on the left-hand side, on the bottom last paragraph, our highest court explained that another line of appellate decisions holds that if a party files a motion to recuse a trial judge and the motion is denied, but it is later determined that the judge should have been disqualified to act in the case, all proceedings after the filing of the motion to recuse are invalid and have no effect. And the reason I raise that is, Your Honor may be aware but may not be, the Honorable Douglas Weinstein filed an initial motion to recuse Judge Glanville. He did that on June 12th of 2024 in the afternoon hours. Judge Glanville initially he stopped proceedings and he denied that motion without referring it to another judge, and he made some findings of why he's denying it. On behalf of Mr. Williams, the Honorable, yes?
Was there a written order?
He did file a written order
June the 14th.
Okay.
2 days later,
All right.
and that was the Honorable Douglas Weinstein.
Okay.
The Honorable Keith Adams and I, on behalf of Mr. Williams, then filed a motion to recuse, but we didn't file ours until June 17th. It's Monday, June 17th.
Okay.
But the way I understand the case law is that once Attorney Weinstein filed that motion, which the Honorable Judge Krause eventually granted. Judge Krause, in a written order dated, I'm going to tell you, July 15, 2024, granted Mr. Williams as well as Mr. Kendrick. Mr. Weinstein represents Mr. Kendrick, both of the motions. So the way I understand the case law is everything that happened after the filing by Mr. Weinstein on June 12, 2024 is invalid.
Okay. So if you would do me a favor and put that in writing and file it as a motion, and then I will add that to our pending list.
Yes.
And I appreciate you letting me know. I don't want to get into substantive argument about anything today because we don't have the parties themselves here. This is basically just a sort of status. So if you will file something to that effect, then I'll have that added to the list. But I appreciate that.
I'll file it today. Can I add one other thing just for your knowledge? But
sure.
If it's something that's more than a status, then
I will withdraw it.
Yeah, and I mean, you can tell me, but I'm, not going to consider it. We're not going to argue it. But yes, absolutely. Go ahead.
Understood. I just want you to know that there was a witness testifying. That's why I thought it's important, which will potentially, if you determine it, require the jury to have their notes, if you require it taken away, and then wiping out what they heard. I just want you to be aware of that.
Okay, I'm not sure if I follow what you're saying now.
So there was a witness testifying. His name is Mr. Copeland.
Yeah.
After Judge Glanville denied that motion, the jury heard from a witness on the afternoon of of June 12th, June 13th, June 14th, and then June 17th. So I just want you to be aware.
All right, I understand what you're saying now. All right, thank you.
Other than that, those are the motions.
Great. Okay. For Mr. Huey, I have got a renewed motion for bond. Is there anything else for, I don't even know which party I'm looking at yet, but.
Again, there are Carson Mack, senior for Mr. Marquez Huey. That is the only motion that I've got at this point.
All right. Yes, thank you. Okay, so for Mr. Stillwell.
So, Your Honor, the way that we had been operating under this case, under the Honorable Judge Glanville was something. Yes, sir. Your Honor, the way that we had been operating under Judge Glanville was there was a thing we named the Harvey Rule, which assumed that all were in agreement and opting into a motion unless we specifically opted out of the motion. So
everybody's joined on everything.
Steele has filed a number of motions that we opt into. And Your Honor, I'll also just point out, there's also the gentleman who's on the stand right now. I think that we need to have a hearing regarding the admissibility of his testimony. I'm not looking at Mr. Steele's motion, but I too believe that we need to look at the co-conspirator exception to the hearsay rule and determine if that applies to the gentleman who is currently on the stand and what he said.
Okay.
And additionally, after Mr. Weinstein's recusal motion, we spent a significant amount of time going back and forth about prior statements and redacting prior statements. And I believe that
prior statements of Mr. Copeland. Okay.
We would have to go through that process again because that was done after the Mr. Weinstein's recusal motion. So we probably need to relitigate that as well. Of course, if it doesn't fall under a hearsay exception, then we wouldn't have to do that. But
okay. And with regard to the question of the admissibility of Copeland's statements under the co-conspirator rule, is there a pending motion or was there an oral motion? Has there been a ruling?
There was a ruling.
Okay.
I don't recall if it's been reduced to writing. I'm going to assume it was. But we've litigated a recusal motion. We've talked about the appearance of impropriety at this point, and from our stance, we need to relitigate it to substance, but just to educate.
But is that what you're saying should be reconsidered? Okay. All right. All right. I am not going to go back. I mean, this case has been going on for how long? 6 months, at least the trial part of it. And obviously I'm parachuting in and I'm just going to have to pick up from here and move forward. I cannot go back and reconsider every evidentiary ruling that's already been made. And I don't think that's what you're asking. I think you're saying because this witness is still on the stand. But I don't know, Mr. Botts, if you were about to say, let's reconsider everything, but we're not going to be able to do that.
Just all the rulings on.
On Mr. Copeland. Okay. All right. All right. And let's see, for Mr. Ryan, and I understand everybody's basically joined in on everything we've already talked about. Is there anything that's individual or in particular to your client that I need to think about?
Yes, Your Honor. And hopefully the state will correct me if I don't have it correctly. But some of what specific evidence the state plans on using each witness has been specified somewhat on a rolling basis.
Okay.
I'm going to give an example. In Mr. Ryan's case, there are 15 recorded interviews.
Mm-hmm.
The state is not necessarily going to offer all 15. Within the ones they might want to offer, there are parts which are inadmissible. Everyone would agree they're inadmissible, but the state has not had a chance to sit down and specifically say, we want these statements, and here's what needs to be redacted, and go back and forth on that. So we don't cross that bridge yet for Mr. Ryan. When we do, you'll have motions of that nature.
Okay, so I'm going to try, and we can maybe get to that in a minute, but I would rather everything that should have been a motion in limine get sorted out. I don't care if we're 2 months from that testimony. But
that's absolutely fine, Judge.
Yeah.
Describe it on a rolling basis is what.
Yeah, well, to the extent we can stop that, we're going to try to get everything done beforehand, but we'll see. We'll see. All right, thank you. And then who else have I still not heard from? For Mr. I will, y'all, in a couple of weeks, I'll know all of this, but I just honestly have not been following this case up until now. So, Mr. Harvey, for Mr. Nichols. And I may need you to yell.
I'm sorry. Better?
Yes.
Per the rule we've been operating under, we're all in on everyone else's motions, barring a on-the-record opt-out.
Okay.
So we're in on everything because we have not opted out as of this point on any of those motions.
Okay.
There may be, I to be honest with the court, I wanted to see where we were today, what our plan was. There may be some additional motions that would be filed on behalf of Mr. Nichols, and perhaps other defendants. If we're going to view this as sort of a logistical status conference, based upon prior proceedings, we've mentioned certain things. We've mentioned certain cases about what may or may not be valid or evidence post motion to recuse. There may be some additional motions that need to be filed. So I would ask that on behalf of Mr. Nichols, that not only we're opting in and we need to now think about whether or not there's going to be any specific opt-out, but to give us some time frame to file any additional motions based upon the unusual proceedings and circumstances in this case moving forward.
All right, so I'm not going to be able to give you a blanket, hey, you get X amount of days to file whatever you want here, because I don't know what it is that you might be contemplating. And frankly, there have been, at least a week and a half that's gone by since whatever the ex parte was that caused all of this. It may be that it's appropriate for another motion to be filed and be considered. It may not be. I'll kind of have to wait and see sort of what it is and why it is only now that it is going to be filed. So I just can't give you an answer on that before I know what it is. But I mean, I'm certainly not precluding anybody from filing. I just don't know if it's something that could have been filed 10 months ago, then I probably don't want to hear it now.
No, I think these circumstances are unique, clearly. So it presents unique opportunities to now move the court now that we have a court. I just
Okay,
don't want
so why don't I just say that if you are contemplating anything, contemplate it quickly and get it filed
5 business days?
before the end of next week, because, and I want us to all look at a calendar in a few minutes, but, the jury has already been given the week of July 29th off, so they won't be back before August 5th, really. So I would like for us to, if we're going to be moving forward with this case, be able to move forward with it and have all of whatever this is going to be out of the way before then. So if you can honestly, because I would also like a response from the state on anything that gets filed. So if y'all can, given that you've had already, a week and a half since whatever went down. I don't know the exact dates of everything yet, but you don't really need 5 more days to think about it. I'd like y'all to get anything that you're going to filed by the 23rd, which is next Tuesday. That may make for busy weekends for y'all, but that is what it is. And then I want responses from the state by that Friday, the 26th. Okay? Which does not mean I'm inviting them. It just means if there are some necessary ones that we need to consider. Obviously, I want them briefed by both sides. And then we'll probably spend the week of the 29th we'll all be here without the jury trying to get as much done as possible, I think. Okay?
And that may answer my next question. I know that on behalf of myself, and I know various other co-counsel, as soon as the words "we're in recess" were uttered, I have emails, specialists at trials. I am inundated by other both federal judges and Superior Court judges. I am asking for protection, and I would assume that co-counsel would join in this protection so that I can say to these other judges, I am on trial, I'm required to be participating in this court, and you cannot set me for trial in another court because I'm on trial. Can we get that protection from the court?
Yes, you shouldn't even need that because we are in the middle of a trial. I don't care whether the judge has changed or not. This trial is ongoing. But yes, to the extent that any judge calls at my chambers, yes, I will tell them, sorry, you can't have Mr. Harvey right now. I've got him.
I want to make those representations in conflict letters. I want to make sure that I'm doing that properly.
Yeah. Now, if there is, because I have been until recently one of the people trying to get a hold of all of y'all for other cases. So if we decide we're taking a 2-week vacation in August, which we won't be, but hypothetically speaking, and y'all aren't in here with me litigating something, then I'm probably going to say you're available, not for a trial, but for, a 1-day hearing or something.
Yes.
Yeah.
I don't mind the 1-day hearing. I do mind going to trial when I'm on trial.
Yes.
So with that,
y'all are all protected from being expected to be in trial anywhere else until the completion, however it completes, of this trial.
Thank you.
All right.
Your Honor, Doug Weinstein for Mr. Kendrick. We have no pending motions other than what has already been stated by our defendant's counsel that we all join in. We will be filing motions before Tuesday, but we have no pending motions. And you said we are going to discuss calendar moving forward? Yes. I have some comments with regard to that.
Okay. All right. Turning to the state. Are there pending motions by the state that need a ruling?
Thank you, Your Honor. There are, and we will have to the court before Tuesday of next week, as the court has made a deadline, there are responses to recent filings by some of the defendants that the state anticipates it will be making. And there are 2 anticipated motions in limine that we will have filed by Tuesday.
Okay.
Based on the court's earlier instruction today, there were matters that are more appropriately placed within a motion that we will have to the court by Tuesday as well. There are, and we will identify all of the ones that we believe exist. There are outstanding, there are rulings that have been made long ago by the court that may not have been reduced to writing. We are working towards identifying each of those, as well as putting into a chart for the court a list of the motions and rulings that have previously been entered.
That would be fantastic, because while y'all all know what the rulings were, I do not. So yeah, a chart and some further information would be great. That was on my list as well. Thank you.
Of course. And we also intend to address, we can do that in the context of a motion, or the court, if it is appropriate today, can address it. We would like to present to an exchange with counsel for each of the defendants what we believe and what we have kept a record of, all of the exhibits that have been tendered, ruled on, and admitted so far.
Okay.
If that is more appropriately addressed in a motion, I can do that, or if the court will permit us or schedule for us a deadline by which to exchange exhibit lists, because the state currently has an exhibit list that we believe is thorough.
Okay.
That includes the exhibits that have been tendered and admitted by both the state and each of the defendants.
Okay. And do you have that like with you and ready right now?
No, we want to present that to the court.
Okay.
We want to compare it with, if the defendants each have one, compare it with those. We want it to be as accurate as possible before we present it to the court.
Okay. So do y'all want to maybe, it sounds like outside of a proceeding, y'all all get together and do that? Or, I mean, if we want to all do it in court, that's fine, but it's not a bad idea.
I would have preferred that the court just order that each of us present to the other the exhibit list that we have, to the extent that they do exist, and that we then endeavor to iron out any differences or discrepancies. So that, for example, by next Wednesday, we each give to each other what exhibit lists that we have, not anticipated exhibits, but the ones that have already been admitted and ruled upon, because there have been moments where exhibits have been shown to a witness or spoken on, and the tendering party represented that the exhibit had already been admitted, and upon closer inspection, the exhibit had not been admitted.
Okay.
So we are asking for a date from the court.
Okay. So when can you have yours ready to dole out to everybody?
We can have ours ready by Tuesday, if we can exchange them by Tuesday.
Okay. Is it, I assume everybody's been kind of tracking this. Could everybody have what you think is the state of the evidence by Tuesday?
I don't think that's going to be hard to do if it's okay.
I mean, frankly, whatever the court reporter has is what's accurate. So it might be that I can just get that list from the court reporter and give it out to all of y'all. And if there is that might be a better way to do it. And then if there is a discrepancy and anybody who believes that's inaccurate, we can take it up. So why don't I talk to and we're going to be, from now on, well, y'all all know Miss Parker, but Miss Parker is retiring in 1 week. I will have a new court reporter, and I know, it's the end of an era, but I'll have a new court reporter, Ms. Winfrey, who probably a lot of y'all know anyway, and she'll be moving forward. I'm going to ask Judge Glanville's court reporter to start working on transcripts because I'm going to need them, but we'll all need them at some point probably, because just transcribing what's happened so far is going to take months and months. So we're going to shift not only judges, but also court reporters. So I will get with Judge Glanville's court reporter and ask her to give me a list of what has been tendered and either excluded or admitted or is still hanging out there. Give that to all of y'all, probably just through email from Ms. Rosser. And then if there is any discrepancies, y'all can let me know that, okay?
That would be great. Does the court, and I understand that there's really no way to tell accurately, but does the court have any idea of when we could anticipate receiving something
I
like
think
that?
pretty quickly. I mean, I've had a couple of communications with her already, and she seems pretty on the ball, and she's tracking it all on an Excel spreadsheet or something. So I don't think it'll take long. I think I can get y'all that by next week sometime.
Thank you.
Okay. Let me write my to-do list. Okay. All right, what else?
Your Honor, I'm reviewing all of the notes from representations made by counsels for each of the defendants, and based on my review of those notes, I don't believe that there are other matters that we need to address at this time that are properly addressed without the defendants here.
All right. And do you have an idea of when you can get me the list of the rulings so far?
Yes, Your Honor.
And I know that's a bear of a task, so
That's okay.
don't want to be unreasonable about it.
Just 1 second, because we have already begun that process.
Great.
And let me, if the court will permit me to confer with our team members who are working on that.
Thank you.
Thank you.
Actually in on this case, or are you just standing in for Mr. Williams today?
I'm actually in on the case. I did file an entry.
Okay, thanks.
And Your Honor, I know that we can have that list before next Friday, or at least by next Friday.
That'll be great.
Okay.
Thank you. All right. With regard to the most immediate scheduling, the kind of getting through, hearing argument on, getting rulings on the things we all just talked about that are pending. Is everybody available all of, and I guess I've already got y'all, unless Judge Glanville had excused you, I think I've got y'all, but is everybody available? And I'm not saying we're gonna be here 8 to 5 every day, the week of the 29th, but is the week of the 29th, everybody's available to the extent we need all of those days?
The state is available.
Okay. Anybody not? Okay, perfect. Because I'm thinking that at least most of that week, that's what we're going to be doing, which means I am not going to be going to the judges' summer conference, but that's okay. That's okay. Okay. All right. with regard to kind of further in the future, just when we're going to be having trial, I think it's maybe been like 4.5 days a week or something. I don't know. I guess it doesn't matter what it has been. Here's what I'm thinking. I am thinking that when we are in trial, we start at 8:45 and go to about 6, at least until the time changes and it gets dark early. And I'll have to obviously make sure that all the jurors can do that. I don't know what their, pick up kids schedule is or anything like that. But I want to make the most of our time, like I said, while we're here and have them. So that's kind of going to be my plan going forward. And it may be that we want to go all 5 days. It may be that we want to, break at lunchtime on Fridays. And if we have other business to do, we stay for the afternoon. And we may not start August 5th with the jury. We may have so much left to do still that we give them another week. But once we do start back with the jury, I'm thinking 8:45 to 6. And when I say 8:45, I mean 8:45. I intend to take the bench at 8:45. I expect I know that the parties, the defendants will be here because the sheriff's office will have them here. I want all the attorneys to be here as well. And if you have 5 attorneys on your side, as long as one of them's here, we're going forward. Okay? So I don't want to be waiting around till 9:30 to get started. 8:45. All right, so that's that. So a couple of things have been brought to my attention that some people might like changed now that have a fresh face. And y'all, some of these are really kind of insignificant, but I'm gonna go ahead while we've got some time and bring them up. Food in court. Everybody can have water whenever they want to. The attorneys can have, whatever drink they want to, as long as you're not klutzy like me and don't spill it all over everything. I guess if you do, that'll be your problem. If we are working through lunch and the jury's out and we're working and y'all are here and the clients are here, that's okay. But snacking while trial's going on, we're not going to be doing that, okay? So if we are working through lunch, if we are working late and it's dinner time, it will be okay to the attorneys or the defendants have food. Not while somebody's on the stand testifying, okay? We're not at a movie. We're not going to be eating popcorn. All right. Hopefully that'll be all I have to say about that. Apparently, one of the first things that I don't know how many different deputies told me was the clothing for the clients has gotten a little out of hand in terms of how much they all have now. I don't know, but y'all need to maybe get together and let's exchange most of that. And sure, they can have new outfits for court, but it sounds like they're like full wardrobes full of clothing for some of these defendants. And that's just a lot for the deputies to have to keep up with. So how about if y'all check in and maybe through Miss Rosser, y'all all know Miss Rosser, I think. She's not even here today. Yes, she is over there. Miss Rosser, my fabulous litigation manager. And let's make sure that it gets whittled down to a manageable amount of clothing, like there are only going to be 5 days in each week. So even if they had a different outfit every day, that would only be 5 outfits, okay? We shouldn't have 20 different outfits for anybody. So y'all need to clear out, apparently, the closet. So now I've done that for the deputies. They'll be more happy. Okay, next topic. Minimizing disruptions in court. I don't exactly know what that means yet, but let's try to conduct court in a way that minimizes disruptions. And we'll just leave it at that for now. There was, an issue about apparently, and I'm not even sure if I understand exactly what has gone on with this, but the defendants listening through earpods to things on laptops while court is going on. And I'm not sure I understand why that's happening, and that raises some security issues with our security staff, with the sheriff's office. So can somebody kind of explain to me what that's about and why that's necessary? And if nobody wants to, then we'll just do away with it.
I think it was originally combat boredom.
All right, well, we won't be bored from here on out. So then if that's the only reason for it, I want to be moving forward efficiently and expeditiously. So let's just plan to not have that happen anymore. And if there arises some new reason for it, then we can address it again anew, okay?
Sure.
Yes, sir.
Good morning again, Sergeant Master Mr. Huey. There are times where the defendant might need to listen to evidence, interviews, things of that nature. And I've made that available for my clients to listen to some of the interviews from witnesses, testimony, prior interviews, things of that nature. For evidentiary purposes, that would be a request for my client to be able to have that access where necessary.
So why is that happening in court? That seems like something that should happen after hours between the two of you.
I certainly understand that. Just maximizing the time that I have with my clients since I don't have availability with them outside of court every day. So he's here, we're here. So a lot of times I'll give them an opportunity to review evidence and things of that nature. So
All right.
that would be the only reason I want to ask.
I'm going to ask that you try to get that done outside of courtroom time. And if there is some sort of an emergency, unexpected reason why something can't have been reviewed before, then you can bring that to my attention. But okay. All right. I would like to find out from kind of everybody how many witnesses there are to go and what you expect those witnesses to say. And one reason I say that is because Judge Glanville had entered an order, which I may not have brought downstairs with me, but y'all, when I describe it, will probably be familiar with it, that essentially said everybody, not really, but several parties have asked for mistrials, I think, because things are moving so slowly. And he entered an order that seemed to say, it appears that the state has 200 and something witnesses. We're on 50 something now. Everybody's causing disruptions, or not causing, but there have been a lot of disruptions because a witness is on the stand and all of a sudden one party or the other comes up with some video that nobody's ever seen before. And that's the reason for all of this disruption. But at the same time, you know, maybe some of this can be whittled down. And that is a wild paraphrase of that order, but I think y'all know what I'm talking about. What I want to know is, where are we really? I mean, I know, you know, witness lists look one way before the trial, and who you end up calling oftentimes ends up being something different. I know this is a multi-count indictment. I know that there are a lot of defendants involved in several different incidents. And I don't expect this right now, but I would like from everybody, to the extent the defense knows whether they're going to present a case or not, a realistic list of witnesses, maybe like what counts they go to and what you expect those witnesses to say generally, broadly. Because this case has been going on for a really long time. And there is a rule that lets me exclude cumulative evidence. And I might end up using that. So how about y'all give me a heads up on all of that, okay? And if that is something that y'all could have to me by next Friday for everybody, that would be great. Let's see, what's next on my list? With regard to kind of just general scheduling, other than the week of the 29th, and then I was told, I think Monday through Thursday of August 19th through 22nd. Is anybody aware of time that has already been given to the jury as you're out of court this week, you have this week free? No? Okay. All right. Does any attorney right now know of a date that nobody from your team can be here? And I wouldn't expect that to be the case because y'all are in trial, but no, I mean, anybody getting married? Okay. So I hesitate to even say the next thing I'm going to say, but I'm going to say it anyway. The little bit I have seen about this case, it definitely has appeared that there have been times that tempers have flared a whole lot and that people have been maybe less than professional. And I hope that this kind of breather has given everybody a breather, and everybody has been absolutely wonderful here today. But I would like for us to maintain a degree of decorum and dignity and professionalism. That is what is really expected of all of us as members of the bar. I don't want to have to say anything beyond that, okay? But if it gets to a point where I think that is not being carried out appropriately, we're going to all have to talk, okay? All right. All right, what else do y'all think that I need to be thinking about, or do we need to be talking about, or at least raising to talk about later? And anything from the state?
Your Honor, I believe that the court has sufficiently addressed everything that we had anticipated we needed to address with the court.
Okay. Now. All right. Mr. Weinstein?
No, Your Honor.
Okay. Mr. Sharp, anything?
There have been, this case, as you know, is enormous, and the discovery is enormous. There are certain, with Judge Glanville, we have some general rulings about some matters, but not particulars.
Okay.
I'm trying to give a heads up. This is an example, but I don't think this is the situation. I have filed a motion regarding, there was a wiretap in this case.
Okay.
And the judge overruled my objections and stated that the wiretap was legal. He made that finding. However, there are other issues about the wiretap and the particular things said in the wiretap. Some of those pieces of communication may be admissible, may not on an individual basis. Certain things like that, I'm just giving the court a heads up, have not been parsed through to the particulars.
Okay.
And we've discussed like the need to do those things, and some of those things we've kind of kicked the can down the road a little bit, so they're still outstanding.
Okay.
I just wanted to bring it to you.
All right. So maybe when everybody is putting their lists of witnesses and what they're generally going to be talking about together, they could also, I don't know what happened to my mic all of a sudden. They could also include if any kind of either voluminous evidence, video evidence, audio evidence that we need to be considering admissibility of before the witness testifies. If y'all can maybe list out for everybody what that is. Because yes, I absolutely want those things to have been determined before, witness Smith gets on the stand and we have 18 hours of some kind of video statement that nobody's thought about yet. I'd like to say I'm sure that all of the evidence has been exchanged by now. Would I be correct in saying that?
There's reports that we're still missing. The state has said that they don't have those reports. Officers have testified that they wrote the reports.
Okay.
And we're still missing.
All right.
That's been a recurring theme.
All right. If everybody wants to detail anything that they think is missing, and I'll hear from the state on whether it is either missing, about to show up, or does not exist, that'll be something we can take up substantively, just so we start out all on the same page. That'll be something maybe y'all can do next week, and we'll take up the week after that as well. Okay, because if we need like 5 days of motions in limine, we need to do that. Okay.
Judge, I just wanted to make clear that the state has complied with its discovery obligations, and we have turned over all of the discovery that exists in this case. And as the court is aware, discovery is that which we have so we have turned that over, and we've actually gotten and requested. We've sought from outside our office any other materials that existed in the universe. We will do as the court has instructed and provide to the court a list of matters we believe have been unaddressed still as they pertain to our requests for reciprocal discovery.
Okay. And Mr. Shard, I know you've been in my courtroom before, and typically I have, one side or the other list out specifically what they think is missing, and we inquire about it and try to get to the bottom of it. So that's what we will do. Y'all make up the list, and then we will do that. We'll actually go through it in detail so that everybody knows what's going on and we all are on the same page. All right. And y'all, for any evidence that there hasn't been a ruling on yet that I'm going to need to consider the admissibility of, I obviously am going to need a copy of that. So if I've got 5 hours of some audio to listen to, I don't want to listen to that in court. I want to listen to that beforehand so that I know what we're talking about before we get to court to hash it out. So get me all of that as well. And that'll be more homework for me to do. Okay. All right. Then, so let's go through anything, either Mr. Williams or Ms. Sabasi for your client. Okay. Mr. Harvey, Mr. Steele.
No, not
Okay.
this time, Your Honor.
All right. Okay. The next thing I want to raise, and I have no idea what has happened before now, but I would like to encourage everybody, while we are kind of in this pause, to talk to each other about whether there are any plea negotiations that might be fruitful, whether there is any room for movement by anybody on anything, any plea. I mean, I'm willing to entertain any kind of plea at any time. It can be a joint recommendation. It will be non-negotiated since we're in the middle of a trial, but it can certainly be a joint recommendation, or it can be state wants this, defense wants that, or it can be we all want to keep going with this trial. I am here to give everybody a fair trial and everybody a fair shake, follow the law. But I invite during this pause, if y'all want to think about that and talk about that, now would be a good time to do that, okay? All right, so I think that y'all have a lot to do and I have a lot to do, and we will plan to get all of our filings and all of our responses in before the end of next week at the dates that I had provided. And why don't we plan to maybe not Monday, but Tuesday, the 30th. All convene here at 8:45 and just start tackling everything that got filed, okay? And we'll plan to go pretty much all day until we finish every day that week. And by the end of the week, I'll know whether we are at a spot to bring a jury in or whether we need another week. All right, anything else from anybody?
I have a question, Your Honor.
Yes.
The court instructed that we provide the court with evidence for which there may be admissibility issues.
Yes.
I wanted to ask for the court's clarification if that meant whether there have been prior motions to suppress filed, or if the court is instructing that notwithstanding the absence of a motion to suppress on a particular piece of evidence, that we are now going to be entertaining motions to suppress. For instance, if there's a recording that we have turned over, will the court be entertaining motions to?
So I don't really know what the expectation has been. I mean, if this had been my trial from the get-go, we'd have litigated all the motions to suppress by now. Motions to suppress shouldn't really be getting filed mid-trial. That being said, I would rather, if somebody is going to stand up and say this is 100% unconstitutional for X, Y, and Z reasons, I shouldn't be letting in something that's unconstitutional for X, Y, and Z reasons. So I'd like to know it, but I mean, I want it to be a legitimate, valid concern evidentially, constitutionally. I don't want it to be, here's my chance to challenge everything under the sun. So I don't know if that answers your question, but it sounds like there are chunks of evidence that everybody has just basically not gotten to yet. And y'all have sort of said, all right, we'll get to that when we get to this witness. And if y'all have been operating on a kind of rolling, all right, when we get to this witness, we'll deal with that evidence, then if that's what the expectation has been, then I wouldn't expect y'all to have all filed all of your challenges. I don't know what's been going on.
Your Honor, that has not been the case. No, but because of the way that the court indicated that the court wanted parties to provide evidence regarding admissibility issues, I just wanted to make certain that I understood what the court was instructing. There have been evidentiary issues that I believe the parties disagree on. The state disagrees with counsel for defendants' interpretation of what is ripe and what is valid for contesting at a particular moment. I don't doubt those will continue to arise, but I was asking as it pertains to what the court instructed just a second ago regarding evidence. I didn't know whether the court was doing something different than what I.
Okay, so I don't intend to revisit rulings on evidence that's already come in. But for evidence that we know is out there and was going to be introduced a month from now with, witness Jones, if y'all have been doing that on a rolling basis and y'all know that there are going to be evidentiary issues with it, things that I would have considered motions in limine, then I want us to all go ahead and voice that now and sort it out so that we know when the witness shows up what can be talked about and what can't be. And I don't know if that gave you clarification. Okay. All right, Ms. Abbasi.
Yes, Your Honor, if I may, I would have to disagree with Ms. Love that it's been going along that we've already had motions about what is and is not admissible. Just to propound on kind of what Your Honor was mentioning and what the task of defense faces, we have a list of 8,000 jail calls. We haven't listened to 8,000 jail calls, and I think probably the majority of them are not relevant. Everyone would agree that they're not relevant. The state's not actually going to introduce all of those jail calls. However, defense are a burden. If we don't raise the objection, it's been weighed, and then it comes in at trial.
Okay, so that's why the witness lists with what this is relevant to and what evidence is going to be used is going to be, I hope, very helpful in giving us all a better kind of groundwork.
Yes, Your Honor, that is precisely what I'm asking.
Okay.
20,000 pages of Instagram is going to be these ones.
Okay.
And Judge,
Yes, sir, Mr. Adams.
good afternoon. Again, Judge Keith Adams with Mr. Steele for Mr. Williams. Just to, I think the court wanted to know if there are things that Judge Glanville had been doing in regards to that particular issue. And I did want to just append to what Mr. Biden was saying. For example, there have been jail calls, there are interviews, that generally speaking, there have been hearings on the admissibility of those statements.
Okay.
But the court has oftentimes said, I agree that, for example, this statement may be admissible, but there may be some things in the statement that's objectionable.
Sure.
We'll deal with that.
Okay.
At that time. The court has routinely been doing that. So not necessarily kicking the can down the road, but addressing issues as they come up. And the court has urged both sides in advance of that issue coming up. If we can get together and iron some things out, let's do it. We've been working to do that. But there have been routinely times where we simply just disagree and we've had to take those items up. And I think what you would like, what Judge Glanville has asked, is that let's let you know about it as far in advance as we can. And that way you can set aside some time to deal with it without impinging on the juries.
Absolutely. I mean, that is, I want to be respectful and cognizant of the jury's time. I also want y'all to all know what to expect to the extent you can, and litigate everything that we can litigate beforehand, if it's going to be necessary. Now, if there's some totally irrelevant Instagram post and the state knows they're not going to use it, but they listed it 1,000,000 years ago, their updated list that they're going to share with everybody should not include the Instagram post that they know they're not going to use. So, all right. So I will expect whatever filings I will anxiously anticipate all of them. Make sure whenever you file anything that you contemporaneously email a copy of it to Ms. Rosser, because the court and chambers do not automatically get what y'all file. I have no idea what you filed unless you actually let us know. So make sure that when you file it, you send a copy to Ms. Rosser so that we know about it. Okay? All right, so I'll plan to see everybody bright and early at 8:45 on Tuesday, July 30th. All right? Don't leave until you make sure Ms. Rosser has your cell information.
Can I ask a question?
Yes.
Judge Glanville had, for both sides, 2 Fridays before that tell the other side what witnesses and what exhibits are going to be in play. I would hope that continues. That would be very helpful.
That sounds like a good idea. So sure, we can leave that as sort of a standing rule. And I suspect that this is true as well, but let me go ahead and say that as we're going through trial, I expect you to have your next witness ready to go. I don't want there to be a 5-minute pause between one witness getting off the stand and the next witness getting on the stand. And the state knows, we're in the state's case right now. The state knows what it's doing. The state has investigative help. Make sure you have enough witnesses to carry us through each day and that they're ready to go. Again, that all just kind of falls under the auspices of let's be respectful of the jury's time. Mr. Harvey.
Can I assume, Judge, that we are going to continue with the opt-out rule so that you're not going to get all 8 of us standing up going, I'm in too?
Yes, no, that's a great idea. Let's continue with that rule as well.
Thank you.
I mean, I plan to basically continue with the rules already in effect unless there's some reason to change them. So I hope if there is something, y'all can bring it to my attention. Otherwise, we'll just keep rocking as before. All right, thanks everybody.
To be honest, remember in the press, there was a rule in place for the members of the press to get the witness list on Friday, so if someone will be excluded to be shown on camera, I want to make sure that's still in place as well.
Okay, so I guess y'all would have agreed beforehand that a particular witness shouldn't be shown on camera, and then who gave the list?
The state has been providing to members of the press the list of those persons, and the judge has made rulings regarding those.
So I saw a ruling that said if there's somebody who, for whatever reason, shouldn't be shown, whatever kind of concerns, then they won't be shown in the, but
it wasn't exhaustive.
It seemed that was kind of a witness by witness thing, and that there was an opportunity for input.
Yeah, there's an order that the judge entered, and there were certain reasons that the state could request that witnesses not be televised. I believe that was to be provided to us the Friday before, and then we would have the opportunity to object to that by Monday.
Right.
And then the judge would make a decision based on his criteria, whether that witness should be shown on television or not.
Right.
And I believe that Mr. Harvey has a standing objection to all witnesses at this point.
Okay. Wait, to all witnesses being shown or being excluded? Okay, well.
No witnesses excluded. I don't want to speak for Mr. Harvey.
All right.
And I'm in concurrence with Mr. Harvey.
Okay, well, that's why I guess it's being taken up on a case, witness by witness basis. So, Ms. Love, then you're providing that to the court and the opposing counsel. If there's objection, we're litigating it. And then are we saying it's like the next Friday that we then tell the press, or help me out on that?
Ms. Hilton says she has been providing that list. I will let her explain to the court.
Okay, because I guess I'm wondering, how is there a list if there hasn't been either agreement or a decision on it?
I believe, I'll let Ms. Hilton start, because she's the one that initially prepares the list.
All right.
Good morning, Your Honor, or good
afternoon at this point.
What has happened is the week before, certain witnesses were going to come up the following week. We would identify any of those witnesses that we are asking not to be shown. We would forward that to the media as well as the opposing counsel. They would then decide, object, and we would hear on Monday the ruling from the court.
Okay, well, so then with regard to the media's inquiry, it sounds like what y'all have been getting as a list from the state is kind of the preliminary, we think this might be the case list. But Ms. Hilton, do you then give them and here's what our determination was list, or?
So normally the court has put on the record that Monday, whether or not that witness should not be shown.
Okay, so you've got your list and you either strike that person off because I said they can be seen, or you just go with what's on there. Okay, that makes sense. So yes, we'll continue with that as well. All right, we're in recess.
So what y'all think, squad? Me, myself, personally, Uh, I'm kind of torn. I'm not liking her attitude coming in. I'm not liking the whole, I'm gonna throw the blanket over your head. Cause she constantly talking about how she has not been watching this trial. Who have not been watching this trial? I've been watching this trial not because I'm a fan of Young Thug. I've been watching this trial because it's been going viral. This is her line of work. You can't tell me she have no idea what's been going on in this courtroom. If you listen to her, she was constantly making references. She actually was sneak dissing about the previous part of this trial. What she say? She want them to be prompt. Not that she want them to be prompt. She gave the time 8:30, 8:45, and when I say 8:45, I mean 8:45. Now, if you've been watching this trial, you all know Judge Glanville say 8:30 and don't come into the courtroom until 11:30. Boys and girls, wipe your feet at the door, keep your nose clean. These people they not playing with us out here. And from the way it looks like they got a plan for old Kenneth Copeland. Y'all heard him mentioning Mr. Copeland's name twice. I seen 2 lawyers get up there and mention Mr. Copeland's name. I think they've been watching his social media. I think he done tripped along the way somewhere and said too much. Chasing the bag. I know the saying is, won't he do it? Who is he though in this circumstance? If you out there chasing the bag, selling your soul, you got to be doing it for the other man. Nevertheless, man, I ain't gonna hold y'all. But stay tuned, cause I'm most definitely tuned in, and you gonna want to be there when Mr. Copeland, Kenneth Copeland, aka Little Woody, as he pronounces it, comes back in that courtroom. The judge acting like she finna flip this courtroom upside down, y'all. Like she tired of watching it. She tired of it popping up in her on her timeline. She and her talking to them like they kids. Something about this lady is, not like I say, I'm kind of torn because this trial has been going on long enough, and if these people are innocent, there's no way they should be sitting inside their jail cell, especially Fulton County Jail. You don't know what I'm talking about. Go back and view my old video with Fonnie Willis. They interviewed Fonnie Willis, and also Judge Glanville. And the man asked them, why do y'all have so many people on this docket that have not been indicted? So they mean they just sitting in jail. They haven't been convicted or nothing. They just sitting in this filthy jail that's falling apart from the inside. No convictions. No bonds. In an unhumane area. But if they are guilty, let's close the books on this one and get the next one up. Because again, I'm going to refer y'all back to those two videos I just mentioned earlier with Judge Glanville and the other one with Fonnie Willis. They got 19 people that's sitting on the docket that's been on the docket for 5 years. Yeah, y'all heard me right. 5 years. Been sitting on this docket. Been in jail, incarcerated, detained for 5 years. Unindicted. So, you know the numbers up under that is staggering. Of the number of people that's actually sitting on this docket. I can't quote the numbers. I did remember those 19 people that had been sitting in jail for 5 years and still yet to see the judge. Man, that's unhumane. And me personally, I feel like that should be unlawful. You holding me and I'm not convicted of anything, but you holding me. 9 times out of 10, a lot of cases, y'all know how it go. We don't have that bond money. Because you done set it, the bar so high, along with the inflation out here, I might have spent my last on the loaf of bread before you picked me up and swooped me up and brought me on in her. Man, tune back into this YSL Young Thug case. Because I think she finna go on and shut the books on this one. And that's the only thing that, but, you know, with all the charges he got against him, she talking like she finna come in there and do this in a week's time, 2-3 days. Like she just done watched the, what's your boy's name? Baldwin case or something. Alec Baldwin. Man, I appreciate y'all rocking with me over here at Fly High Production. I am Mr. Follow Up. I'm out. Squad up.